Hi, my name is Kim Izzarelli, and this is Insights with Kim Izzarelli. Today, joining me is James K. Riley. He's a partner in the law firm of O'Connell and Riley of Pearl River, New York. Jim is an accredited estate planner and a certified financial planner, serving clients throughout the Hudson Valley, New York and New Jersey. Jim only uses the skills recognized in those credentials to provide legal advice and legal advocacy for his clients. In his spare time, Jim is an adjunct professor at Pace University, teaching estate planning, elder law planning, and financial planning since 1993?
Since 1993, 20
1993,
years.
Whew. And he also teaches at Long Island University. He's a recipient of the prestigious Superlawyers designation from Thomsen Reuters legal publishers with a 10.0
Yes.
Rating, and is named in Who's Who in American Law. Jim, thank you for joining me today.
Thank you. Very nice to see you and be with you today.
All right.
My pleasure.
So, Jim, tell us a little bit about estate planning and what are some of the specific things that are important to have in one?
Well, estate planning basically is not planning for the day we pass away, but planning as we go along. It's an ongoing process, and everybody should do it. It's an essential process. One of the most essential aspects of estate planning is people with young children. Doesn't necessarily matter that you have a lot of money or a substantial number of assets. It's that if you have young children, and if both you and your spouse pass away, who is going to do the parenting for those children? Who is going to guard the monies and safeguard the assets until the children are through college? Perhaps a little longer than that, but that is essential. Everybody needs estate planning. Today, estate planning is tied with elder law planning. Elder law is for anybody technically who's over 55 years of age, and they dovetail like a horse and carriage. You have elder law planning, which also includes the concepts that any of us might need long-term care. A risk of that, 1 in 2 over age 75 years, 1 in 2. Astronomical risk as a person ages up. But also, all of us need the essential estate planning documents, which are wills, powers of attorney, and living will or healthcare directive, so that we appoint somebody to be our advocate. If I'm unconscious, I want either my wife or my daughters to be able to go to the hospital and to go toe-to-toe with the medical staff, the nursing staff, that I get the treatment I'm entitled to. And also a living will, under federal law called an advanced health care directive, states that if it is time for me to die, that I'm allowed to die a natural death, that I am not kept alive by extraordinary treatment if it's time. And I always like to say a living will, a health care directive, will not add 1 day to your life, and it will not take 1 day away from your life. It will allow us to have the life that was intended to us by nature or by whatever deity you believe in.
Is there a certain time when people should do this, say after a divorce or a significant change in life?
If there's a life change, we should definitely consider revisiting the estate planning process and the elder law planning process. It should be an ongoing process, a regular process. First, to get basic documents in place. I like to call it the platform or the triangle. Once again, the will, power of attorney, and the healthcare directive. The power of attorney works while you are alive, and you appoint somebody who you trust, a spouse, a child, a close friend, to handle your financial affairs for you if you are unconscious before you pass away. Again, it's an essential document to have. I sometimes joke. I ask the client to close their eyes and imagine the one politician, with all due respects to our political process, the one politician they would not want to have acting as their financial person. And to avoid that possibility, you put the power of attorney in place, and that power of attorney appoints a trusted member of the family or a trusted friend or advisor. So those 3 documents, all of those documents are necessary, and over time they change as our lifestyle changes or our life changes.
Well, you mentioned politics. Did marriage equality change estate planning in New York?
Well, estate planning for lesbian and gay individuals has always been a difficult area because sometimes, with all due respects, the family is not approaching the relationship in a cordial manner, for lack of a better term. And regularly, I still hear of situations on a daily basis where the couple owned the house, they owned it as tenants in common, and one of the couple in a gay or lesbian relationship passes away, and the assets are not going to the other member of the relationship. They go back to family. So if there's an essential need to do estate planning, it's even more emphasized if you're dealing with individuals who are gay or lesbian. But all people need estate planning. And as we approach age 55 and above, all people need the elder planning. Mm-hmm. There's a joke, it's not really a joke, but George Bernard Shaw, the great English-Irish playwright, went to the beach in 1907, and he was swimming out on the beach in the south of England, and he got swept out into the current, just as could happen at Jones Beach, and he wrote a letter to H.G. Wells, the great H.G. Wells, author of War of the Worlds, etc., and said to Wells, you know, I was swept out, and he managed to move down. As a riptide, you move along the shore slowly. But he said, I was swept out into the ocean, and as I was swept out, I had one thought, and the thought was that I had not brought my will up to date. My will was obsolete. And so if it works for George Bernard Shaw, we all should be watching our documents. I say every 5 to 10 years, if you have wills in place, you should be revisiting them.
Okay.
Even today with wills, a will is a written piece of paper that tells your loved ones and everybody else in the world what you want to happen if you pass away with your assets. Most of the time, if you have a couple, the assets will go to the husband or the wife. You do have to be careful if a loved one passes away. It is essential. I had a letter on my desk this morning before I came here, and the widow had written to me that her husband passed away, mm-hmm. and more than 9 months had gone by since he had passed away, and she was just contacting me. There is something called post-mortem estate planning, and it should be done in the first 9 months after a loved one passes away. It's very important. Mm-hmm. Now, under the federal law today, any individual can die with $5,250,000 worth of assets, okay. $5,250,000. So a husband and wife can die with $10,500,000 worth of assets. If the spouse, if the first spouse to die, that spouse passes away, the surviving spouse has to file an estate tax return with the federal and state government within 9 months of the first spouse passing away. If the surviving spouse doesn't do that, in that situation, he or she loses, and the family loses, $5 million worth of exemption. So,
wow.
When you get into the estate planning, certain fundamental aspects of the will cover. First of all, I mentioned already, if there's young children, you want to pick who will be the guardian, who will mm-hmm. raise the children if both spouses are not around. Number two, there's something today, and it's somewhat complicated, called a disclaimer will. It's also called a safety valve will.
Never heard of it.
An option will. Mm. And although the federal estate tax in New York State, if you die, there can be inheritance tax or estate tax on amounts over $1 million.
Okay. So it's much lower than the federal level.
Right, because the states are tax starved.
Okay.
And in New Jersey,
makes sense.
$675,000.
Wow.
If you pass away,
okay.
You have an exemption of $675,000. The federal is $5 million. The way a disclaimer will or safety valve will works is you give everything to each other. That's what we call the traditional I love you will mm-hmm. or sweetheart will. Everything to each other. Now, some estate planners or financial advisors will say that's an estate trap because the surviving spouse has the assets, and when he or she passes away, every asset is taxed. In fact, I joke sometimes that the song by the Rolling Stones, Mick Jagger's song, Time Is On My Side, that was really written by an agent in the Internal Revenue Service in the estate tax section. Because the way it works, the husband passes away. He gives everything to the wife. The wife, as a surviving spouse, passes away in this hypothetical. When the second spouse passes away, that's when the IRS and the state tax people impose the taxation. There's a marital deduction, unlimited when assets go to the first spouse. spouse passing away, assets go to the first spouse, no tax. But the second tax is very, very determined by the taxing authorities. And they can wait 20 years for a surviving spouse to die. The disclaimer will gives the surviving spouse 9 months, the safety valve or option will, to say, I'm not taking all of these assets, and you bounce some assets back into a trust. Normally the trust is for the surviving spouse only during her lifetime or his lifetime. So you basically are splitting the coconut and using the exemptions of both spouses. And it's going to continue to be very important in state inheritance and estate tax planning, because again, the state numbers are very, very low, the exemption numbers. The federal numbers right now, and they may come down to $5 million. It's ironic, back in 1993, I wrote an article for the Times. I was mentioned heavily in an article in the New York Times about the disclaimer will or safety valve will. It was important then, it's more important now, and it helps you to determine the future because decisions are not made. Planning decisions are post-mortem, but the opportunity is there to protect assets. Today there's also tremendous gifting in the estate planning process because under this federal law right now, an individual can give $5 million to the next generation. It's a lot of money, but individuals with substantial assets such as businesses, which they've had for generations, can take advantage of those assets.
So the value of a home, would, since our homes are generally
one of our largest assets.
It's here, especially here in Westchester, relative to the rest of the United States. Does that get folks a lot closer to these limits?
With regard to estate taxation,
does it work? Does it count?
Anything that you can imagine is taxed.
Okay.
That includes, if you're not careful, life insurance can be taxed if you don't plan it appropriately. You really have to have somebody else owning your life insurance or put it into a trust. And a husband can own a wife's policy, wife can own the husband's, and you sidestep the tax. But I have been at my conference table seeing checks being written, not with clients I planned for, but checks being written to pay for estate tax on life insurance. You have to be very careful with that.
Wow.
The disclaimer will is a very, very creative way to establish flexibility in the estate planning process. You sign the will, you put the will in the drawer, and you forget about it. If I pass away 30 years from now, my spouse can take it out and decide whether, 9-month period, they want to use that option or not. The power of attorney we should also talk about. And again, the power of attorney is for somebody who is alive but not able to handle their financial affairs.
Right.
It is like air. It's wonderful and we take it for granted, but when we are in an infirm condition and you don't have a power of attorney, planning opportunities in the family unit are extinguished. They're not available and it can be a disaster.
And everyone's very stressed out at that time.
Extremely stressed out.
They can't think rationally. They're tired. It's usually after a long illness.
Oh, it can be. And the bureaucrats, the financial bureaucrats aren't necessarily cooperative. By the financial bureaucrats, I do mean bankers, stockbrokers, life insurance and mutual fund groups can be very, very challenging. So you do want a power of attorney. I strongly suggest the power of attorney be drawn by an attorney, that it not come off LegalZoom or one of those types of programs for this reason. In New York State since 2009, there have been very, very stringent regulations concerning what a power of attorney has to say. And if you just pull a power of attorney offline that works in Oklahoma, it will not work in New York, and it can be, the results can be devastating. Okay. There's several types of power of attorney. They should all be durable, which means it continues even if I'm unconscious. Durable instrument means that it can still be used even if I'm in the hospital in an unconscious state, and that's essential because that's often why you use the power of attorney. And you can have a springing power of attorney, which I don't recommend. A springing power of attorney says that if I pass away, I'm very sorry, we're talking powers of attorney now, so easy is to get confused. A springing power of attorney says that it can only be used if a physician or doctor, a medical doctor, says that I'm not capable of handling my own affairs.
Interesting.
I don't like springing because it substitutes the medical bureaucracy for the financial bureaucracy, and two other things happen. Have you ever tried to get a note out of a medical doctor's office? It's difficult, and each time you use that springing power, you have to get the note. Even worse, the doctor signs a note saying that you cannot handle your affairs in the springing power, and then you're back and you can. You then have to convince the doctor or the physician that he or she feels you're back, and that can be as big a problem as getting it recognized in the first place. The springing power of attorney, I do not recommend. I recommend that you, in appointing a power of attorney to somebody, your agent who can act for you, you pick a very trusted person.
Okay. Another sort of thing that we're seeing a lot, new dynamic out there, is blended families.
Yes.
And again, a number of people getting divorced, marriages don't survive, and you now have blended families with different ages of children and another set of in-laws and parents to care for. So how has that affected you?
Well, blended families are one of the more challenging areas to plan in, especially for estate planning. If the individuals are relatively young, and they aren't always today with subsequent marriages, life insurance is a way to provide liquidity into the family. I do not sell stocks, bonds, or insurance. I sell no product. I just give advice. But I can look a client across the table in the eye and say, you should have life insurance, because life insurance provides substantial liquidity. You can't take an IRA and necessarily spend it down. If you have a building with a mortgage on it, it's tough to get mortgage money or assets out of that. Life insurance is a tremendous estate planning tool because it does generate dollars into the mix, and dollars are often what is necessary to keep such planning going. Oftentimes couples will give life rights to each other in the house. Okay. Oftentimes with blended marriages, the couples will give significant amounts of assets to each other, but not all, and they might put other assets, which they do not give outright to each other, into a trust, and it's called a qualified terminable interest property trust, or Q-tip. And basically a Q-tip, you're giving the surviving spouse the income off the assets, but not the principal. Now, today you would say income under the statute, 0.5%, that doesn't work. Normally the surviving spouse under Q-tip would see 5% of the assets, principal income pay down. But blended families are challenges in estate planning. Takes some wrestling between the couple. Sometimes I have to leave the room and let them sort of work out how they're going to do it and come back. But once again, there's certain categories of individuals who definitely need estate planning, and blended families is a perfect example again. One of the things I do want to mention in the estate planning process is the importance of comfort. Comfort in the process by the client. The client should never feel in the estate planning process that they have to make an immediate decision, unless they're at the end of their life, then they may have to speed it up a bit. The client in the attorney's office should feel comfortable. They should have the right and feel that they can come back again to discuss it again. I firmly believe and regularly tell my clients with regard to strategies, why don't you think about this? Why don't you sleep on it? There should never be anything that feels forced, compelled, and the attorney should provide information concerning what the fees would be as a front part of that process. The way I normally see it work is the clients come in, you sit them down in the conference room. I like to look right across in their eyes to see if they're getting it or not. You describe what they should consider, like we've done today: wills, powers of attorney, trusts, advanced healthcare directives, and you tell them what they do, and then you let them decide on strategies and come back. Normally, if it's a regular type of estate planning, we're not doing what I call level 2 or phase 2 sophisticated business planning or something like that. If we're putting the platform of the basic documents in place, that should be done within 30 to 40 days. That should not go out 6 months. Put it in place and let them move on with their life.
Are there situations where you bring in a team of individuals, or they'll bring maybe their CPA, or
Absolutely.
in the case of maybe with a disabled child or
All right, let's talk about that. Yes, the more sophisticated the client's asset base, the more likely you'll have a certified financial planner in, or CPA. life insurance person, bank trust officer. If you have a family business, a substantial business of that nature, business planning does require more and often requires things like family limited partnerships to discount the value of the assets in gifting, or limited liability companies. That's a whole second world of estate planning. Before we do that, we have to walk, I tell the clients. You have to do the basic planning.
Right.
Gifting is an important area to be aware of. With regard to a power of attorney, the power of attorney should always say that the individuals have the right to gift assets, because if there's a catastrophic illness, you want to gift the assets down to the next generation. Now, there's look-backs if there's Medicaid involved. And some people say, well, you know, I can give $14,000 a year, and everybody can give anybody else $14,000 a year. There's no tax on those annual exclusion gifts. But they are still subject to what is called the 5-year Medicaid look-back, which soon may become 7 or 10. We just don't know.
Wow.
And what the Medicaid look-back does is this. Let's say I'm 75 years old, and I've done my homework, and I know that there's a 1 in 2 chance that I could end up in a long-term care facility during my lifetime. So I go to an elder law attorney, and he or she will say you have to try to legitimately protect assets. And one way to do protection of assets is to gift assets outright to the children. That's a difficult thing. The children or the in-law children could run off with the money, so you really don't normally do that form of straight-out gifting to the children. One asset that can be protected and is regularly protected is the house. What families do is they transfer the house by deed, filed in the Rockland County Clerk's office, into an irrevocable
or
trust.
Westchester, if you
Right, County Clerk's office. I don't know. I said, or Orange or whatever state. You do this in New Jersey
might be literal
too. But you transfer the asset, you deed the asset into the trust. And you pick maybe one or more of your children as trustees. And then you keep life rights in that asset. As long as you're alive, you have the right to live in that house, or your children could sell that house as your trustee. They're your banker, family banker, and buy another house for you. Take the money. Always the money or the house is in trust. Now, this is called, complicated-wise, a grantor trust, which means if I deed my house into an irrevocable trust, it is still my tax ID number, still my Social Security number.
Okay.
So if I sell my house, if my daughter signs it in the trust as the seller, I get the $500,000 exemption if it's a husband and wife, $250,000 if it's a widow after 2 years or a widower. I get to deduct the income, the mortgage. I'm very sorry. There might be mortgage on it. Mortgage interest. I get to deduct taxes.
Okay.
I get to deduct, if I do have a veterans exemption, an enhanced star exemption, I get those exemptions. And in theory, I still own the house as long as I'm alive for income tax purposes. When I pass away, the house goes to the children, and it steps up. So let's say I bought that house for $100,000, and I pass away and the children sell it for $800,000. They have no capital gain tax. It steps up through the process that it moved to them as a result of my passing away and losing the life rights under the trust. It has to be retained life rights for a step up. After 5 years from the date that you put that trust in place, 5 years, the house cannot be reached as far as the principal value of the house for Medicaid by the nursing home. Before that date, Medicaid can pull the house or any other assets which are gifted back.
So the earlier someone can get started on that, the better.
Absolutely.
Yeah.
And this is a concept of planning. We have to plan. We have to take control of our own destinies. Now, I believe that this is the nicest work an attorney can do, and I do litigation on occasion, but I'll tell you why. Clients desperately need this. And the clients come in, sort of a trip to Disney, and they go through this process of talking about these things. But when they're done and they sign those documents and they've put them in place, they say, Jim, I've been looking to do this for 20 years. I should have done it sooner. I joke that if you do it sooner, it won't make your life, you won't make you live one day sooner or one day shorter, but it will. It will, because you'll have one major item in your life that you're not worrying about. one major item. So all of these factors are just straight common planning factors. The power of attorney, by the way, should have gifting provisions so that if I'm in a hospital and things are not going my way, they're catastrophic, whoever has my power of attorney could gift to the children, to the next generation. But when we do a power of attorney gift, we do one little but if in it. And that is, we say that if a gift is made to one child by the agent, an equal gift has to be made to all other children. It's called most favored nation or safe harbor. So we don't have one child saying, well, I'll take 100,000 and here's 2 for you and 1 for you. Even Steven gifting intergenerational, but gifting is essential.
Very good. What's the hardest question that people stumble on that really takes a lot of time to work through in the process?
I believe the blended family is one of them.
Yeah.
Sometimes, in all cultures, one or both of the spouses just have a hard time thinking about the fact that we're all going to pass away. And I like to say, you know, 100 cents on the dollar, a dollar bill, most of us aren't going to get the full stretch of the dollar. We're going to get 70%, 75%, 80%. Now, I always like to say, and I have a book here on it, General Simon Bolivar, the great South American general, he did a trip at the end of his life down the river Orinoco, I believe it's called, in Colombia and Venezuela. And before he started this trip, in which he visited old soldier mates and old girlfriends and stuff, old only in that long time ago, before he started the trip, somebody said, General, you need a will. And he sort of went wild. I'm General Bolivar. I don't need a will. What are you talking about? Halfway through this barge trip, like a river cruise down this river in South America, he ended up with a bad infection. His there was no paper in the plantation they took him to, and as a result, he put his will, they wrote his will on the wallpaper. There was no ordinary paper because there was nothing to write on. And I say, in planning, don't put your will on the wallpaper. Get it done ahead of time. A good example of planning. Good advice. Very good advice.
So in getting all this documentation and information together, do you provide a checklist before you meet with someone?
I don't. You know what I say? Come in. Okay. We'll deal with the paper. We'll deal with the assets later. Okay. Because most couples today, especially if they're working, they're not going to get the paper together. But half the items we can pull down from the Westchester County Clerk's Office website or whatever other county. Where they live. The other assets we can put in there over time. You normally do want to know how the assets are structured. Are they joint? Are they tenants in common? Are they owned in one name? Is there a beneficiary designation? But you can start to move forward. You don't have to wait. And it's not best not to wait 6 months trying to find that last piece of paper. If you're doing your taxes, you can go and get a will done. Same basic information we could take right off the income tax return.
Sure, and it's this time of year right now where people are getting that information together. So
absolutely.
Make the call. So, anything you want to add, Jim, that we didn't cover just in our last couple of minutes here?
Well, the one thing I do want to mention is that there's a bad fraud going around that everybody should know about, and I've seen it in the elder law sector, and that is that a lot of couples and individuals put on reverse mortgages and they put on home equity lines of credit, and then they are sitting there, so to speak. There have been some very, very bad identity thefts coming out of Korea.
Wow.
It's frightening. They'll pull down the individual's line of credit. I know of one where there was a pull down of $140,000. So if you have a line of credit or a HELOC, home equity line of credit, or a reverse mortgage, make sure, I would go to the bank and say, I don't want that live. I don't want somebody to be able to steal my identity and pull it down. I really would like it locked up unless I come in and put it on a piece of paper. And the law is dramatically different if it's an electronic pull. There may not be as many rights against the bank as if it's on a piece of paper. Wow. And I'm seeing that. The other thing, everybody should go and look at their automobile insurance and have the maximum supplementary uninsured motorists they can have. You're riding along in the car with your grandchildren. You hit a car. You probably be very responsible. You have good insurance for the driver or passenger of that other car. You do not know what kind of coverage the other car has. They hit you. They cause the accident. irresponsible driver, orphan, irresponsible insurance. So you might have more insurance for the stranger than you have for your own children or grandchildren in the back of the car. You should maximize your uninsured motorist coverage. If you have a $250, $500 policy, liability,